All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Demystifying Florida's Public Records Laws and Unlocking Your Advocacy. Before I introduce our speaker, I'm going to go through some quick housekeeping announcements. This training is being recorded, so you're going to receive an email from Zoom within about 24 hours or so with the link to the recording, the link to the materials, and the CLE information. We may end up uploading it to YouTube. If you will probably get a private link, it may be public. We're still not sure, but in the YouTube link, you will also find in the description, you will also find the CLE information and the materials. Speaking of CLE, this training was approved by the Florida Bar for 1.5 general CLE credits. I'll announce that CLE code towards the end. I will drop it in the chat, and it will also be going out in the email and in the YouTube description. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or the captions, feel free to let me know. This training is being co-hosted by the Public Interest Law section of the Florida Bar or PILS. If you're not familiar with PILS, I'm going to drop the link into the chat. One of the committees that we have with PILS is our Advocacy Committee, which is where this idea kind of came out of. And it's one of the training areas that we identified. So I highly encourage you to take a look at the Public Interest Law section website, which I'll drop in the chat in a bit. And final piece of housekeeping announcements are questions and answers. This is one of those topics where you will probably have some questions. We do ask you to hold your questions towards the end. We save some time towards the end for questions. If for whatever reason we can't get to your question, feel free to email me your question, and I'll make sure to share the question with our speaker. And materials, I will share a copy of the materials as soon as I pass it over to our speaker. I'll drop the link in the chat in case you want to follow along in addition to the slides. So without further ado, it is my pleasure to introduce our speaker today. Our speaker is Tony DePalma. Tony is the Director of Policy and Advocacy for Disability Rights Florida, the state's federally authorized protection and advocacy system, benefiting all Floridians with disabilities through the provision of free and confidential legal and advocacy interventions specified across 10 or more federal grants. Before this, Tony worked as an attorney, policy and budget analyst, and special master for the Florida House of Representatives and was an assistant general counsel for the Florida Department of Elder Affairs. Tony attended Florida State University, receiving bachelor's and master's degrees in communications and a law degree from the FSU College of Law. Tony moved to Tallahassee for college in the late 90s, never left, and once owned a t-shirt proclaiming the city of Florida to be Florida with a southern accent. So without further ado, I'm pleased to pass it over to Tony. Tony, the floor is yours.
Thank you, Jorge. And about that shirt, I can't find it anymore. I really did used to have a shirt that said Tallahassee is Florida with a southern accent. I talk about it all the time because I think it's spot on, but I don't have that shirt anymore. So good afternoon, everyone. My name is Tony DePalma. I have the very good privilege of being the Director of Policy and Advocacy at Disability Rights Florida. In our Tallahassee office, I use he, him pronouns. I am white with a red shirt. Let's call it short, shaved brown hair, and a big white beard. Behind me is a palm tree and a beach and rolling waves. Because as just about everyone who's attending this might know, we are in Florida and we have a government in the Sunshine Framework that is well established, well noted, well revered, but very difficult to engage with and activate your advocacy, as you can see the title of this presentation. So as Jorge mentioned, this is a training being brought to you by Florida Legal Services, the statewide training initiative, and the public interest law section of the Florida Bar, and us, Disability Rights Florida. Disability Rights Florida, I will give a little bit more information about our organization in a minute. You might be asking yourself, why is a disability rights advocate explaining Florida's public records laws to us? Well, I got put up to this. I gave this training internally to our staff as a means of helping our staff learn some different advocacy tools, some different advocacy avenues. And I was recommended to give the training to Jorge and Florida Legal Services for the possibility of giving a presentation and a training to everyone. So that should answer that question. But I just wanted to mention real quick that although this training is being brought to you by all these legal organizations, Florida's public records laws are decidedly, they don't require you to have a law degree. They don't require you to know the ins and outs of the law necessarily. But All that said, the public records laws of which we are going to review today together are certainly a maze and certainly benefit from having a working understanding of how the rules work, etc. Um, and I must mention, so I have had a chance to give this training at DRF to our advocates and attorneys. In a past life, Jorge mentioned I worked at state agencies. I had the opportunity to give this training to agency staff. You can imagine those are two very different trainings. No part of this training today is given with the purpose or the intention of trying to get one over on state agencies or to denigrate the work of anyone at state agencies. I kind of think of it like a board game. In any board game you open for the first time, you sort of read the rules, you turn over, you splunk the pieces out, and you start playing. So hopefully at the end of this training, everyone will agree that this is a good introduction, kind of something akin to turning the board game over and starting the game. So without further ado, we will go ahead and begin. All right, so as I mentioned, Disability Rights Florida. Since 1977, we have been the state's congressionally authorized protection and advocacy system, or P&A, benefiting all Floridians with disabilities through the provision of free and confidential legal and advocacy services as specified across 9 or more federal grant programs. On this slide, you will see our contact information. We have ways to get a hold of us through mail and fax, online, TDD, which is telecommunications devices for the deaf, and also relay options to request information, referral, resource, and assistance. I should mention here that when we're talking about public records, it's important to know that public records, there's many different ways to get them. When we talk about public records laws at Disability Rights Florida, we talk about these different ways to receive records, sort of in terms of what is most difficult, what is easiest, and what is most cost prohibitive, what is cheapest, etc. So it bears mentioning at this juncture, I think, that you can receive records just by asking. So, always keep that in mind as we're talking about public records laws. Sometimes records are simple to get just by asking for the record. Similarly, records are usually very easy to get with client authorizations. If you're representing a client and you're trying to get that client's records from an agency or from someone that client has interacted with, client authorizations make that easy. Folks tuning into this might want to know the difference between Freedom of Information Act requests and state public records requests. Those are both two, one's federal, one's state. Those are both two different ways to get records, and we'll talk lots today. At Disability Rights Florida, we have a unique authority called Access Authority, which allows us, when we have a suspicion of someone with a disability being abused or neglected, we have the ability to request records sort of in an immediate capacity. That's a different way to get records for us. And then, of course, there's litigation. As anyone who's been involved in litigation or attorneys on the call might know, litigation includes a process of discovery, which is basically the moment where everyone involved in litigation shares their relevant records with each other. So across all of those are many different ways to get records that you're looking for. Let's dive into a little bit about what this training is about specifically, though. So Florida's public records laws. Today's training will walk you through what is government in the sunshine, a little bit of the background and its origins, some of the scope and application of Florida's public records laws, ways to make a public request the correct way, different considerations as you're making a public records request, the ways that those requests are thereupon processed and responded to by a state agency, and then a little review and discussion about remedies and penalties for when things might not go swimmingly or as planned. Moving forward a slide. So probably the first thing to clear up is, what is government in the sunshine? So government in the sunshine is a concept. It's really not a part of the statutes per se. It's really not a requirement per se. It's more of a philosophical concept. So Florida's public records laws provide a right of access to the records of state and local governments, as well as to private entities acting on their behalf. This is some of the very high level understanding of how all of this is set in motion. So in the absence of a statutory exemption, which we'll talk a whole bunch about in a bit, this right of access applies to all materials made or received by an agency in connection with the transaction of official agency business, which are used to, and this is important, perpetuate, communicate, or formalize knowledge. Uh, I included the relevant citations. So when we're talking about the state's Public Records Act, we're talking specifically about the statutory Public Records Act, which is in Chapter 119 of the Florida statutes. Today's presentation and conversation will be mostly about that chapter of law, Chapter 119. It's also important to note at this juncture, however, that this right of access is so well established that we now have a constitutional right of access in Florida. And that constitutional right of access is found in Article 1, Section 24. And I have notes that I'm just trying to make sure I'm not glossing over anything. And I almost did. And here's something important I don't want to gloss over. So, as Jorge mentioned, we will answer questions at the end of the presentation as best we're able to. It's very likely that some of the hairier or more curveball-y questions that might get tossed out are ones that I'll remind folks to seek legal counsel and get legal opinions on. Nothing that we're providing today is intended or should be construed as legal advice. We're really just trying our best to sort of level the playing field, explain how the framework looks and works, and just take folks through a tour through everything. So moving on. All right, so here's a little bit of the history. And this is actually pretty fascinating. Chapter 119 was passed in 1909. That's 117 years ago, y'all. That's a darn long time ago. After 1909, in 1967, Florida passed a government in the Sunshine Law. So that law is commonly referred to as the Sunshine Law. What happened in 1967 is a basic right of access to most meetings of boards, commissions, and other governing bodies of state and local government agencies and authorities was commemorated. So when we talk about the open records laws or open government laws in Florida, we really are talking about both the open records, like public records laws, as well as our, Floridians' right to access meetings. So it's open meetings and open records. Those are two distinct concepts. Today's conversation will largely, if not exclusively, be about records and not meetings. This right of access, and again, it's important to know that Florida was the first, I believe. Maybe someone can check me on that if I'm wrong, but I believe Florida was the first state to pass a right of access to its records of its government and agencies. This right was so important, and at this point, every state in the union has a similar law. But in 1992, Florida voters commemorated this with the Sunshine Amendment, of which we just spoke. And largely, this put the power of how this all works in the hands of Floridians themselves. And in Article 1, Section 24, the most practical reverb that came out of it was the legislature must meet a strict 2/3 supermajority vote to pass any future exemptions to the public records law. And we'll explain in a bit what exemptions are, how those are passed, etc. Here's maybe the most important thing I could mention in this entire training. So if you're only tuning in for the CLE code and one bit of information, here's that one bit of information. So each year, a Government in the Sunshine Manual is published by the First Amendment Foundation in cooperation with the Attorney General's Office. So the 2025 Sunshine Manual is out there for your review. It's about 400 pages long. This is the part of the presentation I want to give a shout out to the First Amendment Foundation. I learned all of this and I became interested in all of this, as I said, as a member of Florida government. But I learned the ins and outs of all of this and some of the importance, and then the importance was impressed upon me years after by the First Amendment Foundation, their former executive director, Barbara Peterson, who is widely understood as sort of the expert on all of this. So as much as I'm playing a bit role or doing my best to sort of be an understudy and talk about these laws and stuff, the First Amendment Foundation really is the vital reservoir of information about how all of this works. They have helplines that they will go through issues with folks. So, when there's any doubt about how any of this works, always remember that the First Amendment Foundation's out there. Also, this is a great point to say that even though the First Amendment Foundation is constantly at odds with state government in terms of trying to get records produced and stuff, they actually work in concert with the Attorney General's office to put out the Sunshine Manual. This Sunshine Manual of which I speak, in addition to being about 400 pages, is meticulously indexed and annotated. It has just about every answer you could ever imagine within the manual. The manual itself is keyword searchable. There's an extensive table of contents. So this is the hour and a half sort of talking version of all of that, but I would highly commend anyone with even a passing interest in how this works to go and hunt out the Sunshine Manual and dig in accordingly. Also, we'll talk a little bit about how records requests work for law enforcement agencies. It's important to note too that there is a separate manual for uh, public records laws related to law enforcement agencies, also published by the Attorney General's office. So if any of those issues are ones you want to get deeper on, just know that there's a whole separate manual for that. All right, advancing a slide. All right, so we will get in now to the scope and application of Florida's public records laws. I just wanted to mention real quick that the painting that you will see uh, on this slide and throughout the presentation is titled Dancing Train by Kristen Bouchard. Kristen Bouchard is an artist at a Pyramid Art Center in the state, and we were lucky enough to be able to purchase Kristen's art or purchase the use and licensing of the art to include with our annual report and things like this. I think it's a great painting. So thank you, Kristen. All right. So the 40,000 foot view, talking about the scope of public records laws. Like, what are we talking about when we're talking about public records? Who must respond? What is an agency? I intentionally tried my best to make this presentation not legally dense. I included only a couple statutory citations where I felt that they were very important to share. So here are two of them. The definition of public record is broad. How broad? Pretty broad. So public record includes all documents, papers, letters, maps, books, tapes, photographs, films, sound recordings, data processing software, or other material, regardless of physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance, or in the connection with the transaction of official business by an agency. So important to note whether that is a record is a record, whether it's in draft or final format. You can't remove something from being a public record just by stamping draft on it, or indicating that a final version will be forthcoming. And unless a specific statutory exemption exists or the records are made confidential elsewhere, a public record must be turned over upon an adequate public record request. Now, who must turn these documents over? Agencies. Well, who are the agencies? Are we only talking about the large named agencies within state government? We're certainly talking about them. But what else are we talking about? So agency in the Public Records Act includes any state, county, district, authority, or municipal officer, department, division, board, bureau, commission, or other separate unit of government created or established by law, and any other public or private agency, person, partnership, corporation, or business entity acting on behalf of any public agency. So we're not just talking about all the agencies as understood and as named in state government. We're not just talking about boards and commissions. We're actually talking about a whole universe of other records custodians that must comply with the public records laws, which means that there's a whole trove of information out there that is constituted with public records that you as an advocate or someone interested in this information potentially has access to. So let's dive deeper together. All right. Okay, so when we talked about agencies, very clearly the Department of State, or the Department of State, the Department of Elder Affairs, the Department of Children and Family Services, like all of these agencies obviously are agencies. But what other entities are covered? So advisory boards are covered. Private organizations can actually be covered as well when those private organizations are acting on behalf of a public agency. So this can include private entities created pursuant to law or by private agencies. It can include private companies' delegated authority to keep certain public records, and it can include subcontractors to those agencies. The broad definition of agency ensures that a public agency cannot avoid disclosure by contractually delegating its responsibilities under the Act to a private entity, which makes a lot of sense if you think about it. I mean, in the grand scheme of things, if you were allowed to sort of uh, absolve yourself from having to be responsive to the Public Records Act just by subcontracting out for records possession, pretty sure a lot of agencies would do that. Um, and not to go too into the weeds legally here, but to try to separate this and pull it apart to understand when a private entity or organization has to respond to a public records request, courts use two different tests to determine whether that's the case. And those are both the totality of factors test as well as the delegation of functions test. Just know those two things exist if you're interested in either and going deeper on either. I'll advance a slide. So, what entities are excluded under the Public Records Act? So, here's an interesting point. Earlier, we mentioned that in 1992, Florida passed a constitutional right of access. That right of access is very broad. If you read Section 1 or Article 1, Section 24, you'll see how broad exactly it is. So, whereas that is a broad right of access, Chapter 119 is actually a little bit narrower. Chapter 119 doesn't apply to the judiciary and doesn't apply specifically to the legislature. Although, because of that constitutional right of access, the Florida legislature's records are available for public review under Section 11.0431 of the Florida statutes. And Florida courts likewise have their records reviewable by the public under a rule of judicial administration that I've included on the slide. The governor and cabinet, the act only applies to the governor or cabinet members when they're sitting in their official capacity as a part of a board created by the legislature. Although that's the case, constitutional right of access still applies to the governor and the cabinet unless specifically made confidential. You can imagine this is where a lot of the fighting happens, trying to get records out of the governor's office. And there are some carve-outs. For instance, all clemency records are excluded, and the release of such materials is governed by the rules of executive clemency adopted by the governor and cabinet. So just understand from this slide that although Chapter 119 itself only applies to state agency records, as broad as that is construed, it does not itself apply to the legislature or the judiciary or to the governor and the governor's cabinet, but the constitutional right of access certainly does. And parsing that out and understanding the distinctions there is a little bit above and beyond what we have time to do together today. I just kind of wanted to make the point together. So, all right. What records are covered? So, earlier we mentioned what a public record is. It's very broad. It includes maps. But it's most important probably to note here that in the year 2026, where the rubber meets the road with a lot of this are around electronic and computer records. So these are not just emails. These includes things like calendars, databases, and word processing files. Word processing files, even if they have draft written on them, you'll remember. Email messages certainly count as long as they are made or received in connection with official business. And we'll talk a bit about retention schedules and destruction of records. It's important to note here, email messages are subject to this are themselves subject to the statutory restriction on destruction of public records and may be destroyed or disposed of only in accordance with the retention schedules established by the Department of State. We'll talk a bit more about those retention schedules later in the presentation. Electronic and computer records also include text messages, as long as those messages are made or received in connection with official business. You can imagine that's a whole new avenue of record that is fought over and about in the courts and between requesters and requestees. But it's probably important to note, if I was giving this training to agency staff, I would really pause here to explain the different considerations that are bound up in the fact that text messages can be public records. There's that old saying, like if you're not comfortable with something appearing on above the fold and on page 1 of the New York Times, don't ever write it somewhere. You know, that might be a little bit true here if I was training state agency folks. So, and again, this might be the third time I've sort of hammered this, but drafts and notes. So there's no unfinished business exception to the public inspection and copying requirements of the Act. Keep that in mind if you're trying to find something like a memo or a draft of a memo or early versions of a memo or a memo with annotated notes or edits on them. I mean, those are all public records that might be or might not be interesting to you for one reason or another. So advancing a slide. So more on the records that are covered. So we talked about law enforcement records. We mentioned that there is a separate sunshine manual for law enforcement agencies responding to public records requests. I would commend that to anyone interested, but it's important to note arrest and crime report records are generally considered to be open to public inspection. However, exemptions exist for juvenile offender records, certain victim information, as you can imagine, confessions, and this is the big one, active criminal investigative and intelligence information. So now, just on that note, I just want to, one of the big takeaways from diving deeper into the law enforcement avenue or realm of public records law is what that actually means. And so just wanted to note here. So to be exempt, information must be both active, which, keeps law enforcement agencies from saying that their criminal investigations always active or just ongoing forever. And the record itself has to constitute either criminal investigative or criminal intelligence information. So if folks have an opportunity to make records requests to law enforcement agencies, those are some of the things you'll want to think more deeply about as you're teeing up those requests. All right, so other records that are generally excluded. Adoption, birth, death, autopsy, abuse and protection, and domestic violence records are examples of records that may be made confidential and or exempt by law, or that may have aspects of their production or inspection limited or narrowed by law. Agency attorney work product, as you can imagine, that they've made sure that the Public Records Act isn't a clever way to see the working product of attorneys before litigation or anything. Those are excluded until the conclusion of adversarial proceedings. So always keep that in mind as well, that something that could be construed or deemed agency attorney work product, that's a time limited concept. And there becomes a moment when you should be able to see that, assuming. And then also patient records. So patient records are generally protected from disclosure. Patient medical records made by healthcare practitioners may not be furnished to any person other than the patient, their legal representative, or healthcare practitioners and providers involved in their care or treatment without that authorization we were talking about earlier. And this includes patient clinical records. I put a note in here for our staff. This is the central client records for the Agency for Persons with Disabilities, as well as the Baker Act clinical records kept by the Department of Children and Families and certain managing entities in the state. So I will move forward a slide. So what is the process of providing public records? How does that look? How does it work? How do you make a request, et cetera? So first of all, we should stop for a second and consider who is a custodian of public records, right? You probably can't see because I'm on a beach, but everywhere around me, I have paper. I have 3 separate desk surfaces, paper everywhere. So if I was working at a state agency, am I the custodian of all of these things? Am I the custodian of my colleagues' records in their office? What if that colleague left or never came back to work? Who's the custodian then? So custody and understanding what constitutes a custodian of a record is important. It's actually very important. So here's how this breaks out. Every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so. At any reasonable time, under reasonable conditions, and under the supervision by the custodian of the public records. So let's tear that apart a little bit and think about some of this. The fact that a particular record is also maintained by another agency doesn't relieve the custodian of the obligation to permit inspection and copying. So just because if I work at the Department of Juvenile Justice and certain records that I keep are also maintained by the Department of Children and Families, that doesn't mean that if you ask DJJ for the record that I can get away and just go, well, that's DCF's record, more or less. You're going to have to go, chase that down with them. So that is not a way to skirt the public records laws. Also, an agency is not authorized to refuse to allow inspection of public records on the grounds that the document are in the actual possession of another agency or official, sort of the same idea there. And if information contained in the public record is available from other sources, a person seeking access is not required to make unsuccessful attempts to obtain from those sources as a condition precedent to gaining access. So in that instance, we just illustrated, if I work at the Department of Juvenile Justice and you're making the records request of me for a record that I know is in DCF's possession as well, I can't respond and tell you to, go talk to DCF, and if they deny you, then you can come to me and we'll talk about getting the record from me. Like that does not relieve custody. I am still a records custodian in that instance. So advancing the slide. All right, so here's the actual ins and outs of making a record request. I'm going to reverse the slide, so I apologize for that. A couple more thoughts about custodians. It's important to note that when you're going and looking for records, especially from like a big agency, an agency or an entity that has a public record shop, or on their website it has like public records, you typically see a lot of those records requests get funneled through to agency clerks or records custodians, public records coordinators. The name of the individual really doesn't matter. And there is some nuance to what constitutes an agency clerk, et cetera. Think of these individuals as just the people receiving the request, not the only custodians of those records. Like if I was an agency clerk for the Department of Elder Affairs, it's not only my obligation to have all of the records for elder affairs there. That obligation flows. So just know that when you're interacting with someone who's titled as an agency clerk, they're not the only person that has custodial obligations. So now we'll advance the slide. Here's 6 slides on how we make these requests, because this really is the heart of the matter, I think. So the law provides any member of the public access to public records. And now here's the important quote: whether he or she be the most outstanding civic citizen or the most heinous criminal. That's wild, right? And if you think about it, it makes a lot of sense. So a requester may not be required to disclose their name, address, telephone number, or the like to the custodian, unless the custodian is required by law to obtain this info. And then they are in some limited instances. Uh, but if and then finally, a requester is not required to explain the purpose or the reason for a public records request, as, quote, the motivation of the person seeking the records does not impact the person's right to see them. So an agency is not authorized to impose conditions or limit access to public records based on a suspicion that the request may be for an improper purpose. And the fact that a person seeking access to public records wishes to use them in a commercial enterprise similarly does not alter that right of access granted in law. If you think about it, even if the person is seeking for information for a potentially predatory or improper purpose, that is not a distinction that matters to the public records law. Because again, that would be adding too much subjectivity to how the requests are responded to and how they're fulfilled. So if you take all of this together, when you're making a public records request, you don't have to do it from a particular email address. You don't have to use your name. You don't have to include justification language for why you want the information. We regularly see requests for information that are transparently commercial. Folks are looking for records from an agency that help them understand everyone in a certain zip code that is above this age who receives these services or that, so they can be marketed to. That is absolutely okay. And you shouldn't try to frustrate a public records response because you have suspicions that that might be what's going on. And really none of this is pro tip nearly as much as it's just trying to illustrate like the true breadth and scope of the public records law. Moving a slide, slide 2 of 6 on making a records request. So custodians of public records must acknowledge the request promptly and respond to such requests in good faith. So such good faith response includes making reasonable efforts to determine from other officers or employees within the agency whether a particular record exists. This duty of good faith is subjective, such that whether an entity acted in good faith is necessarily a question for the court to decide based on findings of fact. And an agency may not maintain a policy providing for an automatic delay in production. Now, I know this was so, there's 2 concepts going on here. There is a requirement for a prompt response, which shouldn't be delayed. In very limited instances should that ever be delayed. And then there's a requirement for reasonable production. And those are two different concepts to hold in mind as we're thinking through all of this together. Um, Suffice to say, though, if you make a public records request and it just goes unresponded to, that's already a problem, regardless of how fulfillment occurs or what the next exchange is. If you make a public records request to an agency that doesn't get responded to, or that gets responded to in the specific time delay or like a delay as a matter of course, that's not how Chapter 119 is supposed to work, and that would be a problem. So, examples of potentially permissible production delays, again, the types of things that after an agency responds to a requester that might allow for production delays include delaying production to determine whether the records exist or whether requested records are exempt, or to await receipt of required fees from a requester. Otherwise, the only delay in producing records permitted under the Act, and this is really important language, is the limited reasonable time allowed the custodian to retrieve the record and delete those portions of the record the custodian asserts are exempt. Uh, so, and an agency's unjustified delay in producing public records constitutes an unlawful refusal to provide access to public records. However, and this is kind of the countervailing thought to that. The Act demands prompt attention in a reasonable response time, not the quickest possible response. All of that I just mentioned, you might be really frustrated or surprised to know that if you open Chapter 119 and look through the different provisions, you won't find a required time. Like, and a records custodian must respond within 1 week or 1 month. You won't find that. Really, the reasonableness of any delays in responding always ties to what's being requested, whether that's a whole lot of documents, a big volume of documents, or as we'll start to talk about in a bit, whether the documents you're requesting truly do take a little bit of time or a lot of bit of time to review and redact and create a redaction log, etc. So let's get into a little bit more of how the public records law accounts for those types of situations. I am checking time real quick just to make sure. Okay. So an agency may not require that request for records be in writing. We mentioned this. So a custodian must honor a request for copies of records, which is sufficient to identify the records desired, whether the request is in writing, over the telephone, or in person, provided that the required fees are paid. So a records request can be made over the phone. Although it's probably not the soundest advice to make records requests that way, because you wouldn't be developing a documented record of the request. A records request can be made. The records request can be made in passing. As long as what the information that's being sought is readily identifiable and sufficiently identified, then it is a inbound records request. The Act does not mandate that an agency creates new records to accommodate a request for information. This is another supremely important point to hold on for a second. So the intent of the Act is to make available to the public information that is a matter of public record in some meaningful form, not necessarily that which the applicant prefers. And accordingly, an agency is not ordinarily required to reformat records to provide them in a particular form as demanded by a requester. Also, it's important to note, and this is sometimes where a lot of young advocates get tripped up. Chapter 119 public records request isn't for the purpose of asking questions. Isn't for the purpose of asking the Agency for Healthcare Administration, like, hey, tell me how many long-term care waiver enrollees have disenrolled last week, in this capacity or that capacity. Like, that would only be a record if the agency has a record showing that information. So a public records request can't request for information to be reformatted in a way that it would work best. A lot of times the records you get from an agency really do reflect the fact that these aren't that these records are in cells of Excel spreadsheets and stuff. As much as you might really wish that some data person at ACA would crunch the numbers and run those Excel spreadsheets so I can find out how many LTC waiver disenrollments there were in Broward County last week. That's not how the public records law works. So it really isn't based around asking questions or just passing curiosity. It really is a hunt for a tangible document. And again, if you remember how broad the definition of public records is, it's really not just like a piece of paper or an email. It can be a lot of different things. Advancing a slide. So when and how does inspection occur? So it's important to note that inspecting a public record is a little different than copying a public record, which it can also be achieved through photographing a public record. All of this is sort of embraced and inferred at different points in Chapter 119 and in the framework of public records law. But here's a little bit of what we mean. So the Act authorizes inspection and copying of public records at any reasonable time. So what does that mean? So a custodian may reasonably restrict inspection to those hours during which their office is open to the public, typically Monday to Friday, 8 to 5. An agency policy restricting inspection to the hours of, for instance, 8:30 to 9:30 is inadequate. That would frustrate the intent of the public records law. So if you make a public request of an agency, you are able to inspect those records during their business hours. Nothing in the Act requires that an agency respond to a so-called standing request for production of records that it may receive in the future. That's another sort of pro tip that we have to remind our advocates as they're learning this process and these processes. As much as we would really love to know, like, exactly how many child protective service investigations are emanating from this facility or this county moving forward, you can't make a public records request to an agency saying like, hey, every time you get one of these, make sure you send it to me. But if you're savvy, you really can do something kind of similar to that if needed. You can develop end arounds for sort of the same type of standing request, but you really still have to make the request anew every time. And it's important to note an agency may not bargain away its duties under the Act with promises of confidentiality in settlement agreements or contracts. So no NDAs, no contractual bargaining of the right of production or being responsive to a public records request that is out of bounds. Moving forward, this is slide 6 of 6 about making public records requests. So if a custodian asserts that an exemption applies to part of the record, the custodian shall, quote, redact that portion and shall produce the remainder of such record for inspection and copying. So the fact that an agency believes that it would be impractical or burdensome to redact confidential information from its records does not excuse noncompliance. And a custodian of records containing both exempt and non-exempt material may comply by any reasonable method which maintains and does not destroy the exempted portion while allowing public inspection of the non-exempt portion. So there's been lots of records like this in the news these days. I think folks are pretty well acquainted with how heavily redacted paper looks. Sometimes there's only 2 words you can read and everything else is blacked out. That's 100% how a public record can look post-redaction. Also important to know the custodian of a public record who contends that a record or part of a record is exempt from inspection must state the basis for the exemption, including its statutory citation. And upon request, that same custodian must state in writing and with particularity the reasons for the conclusion that the record is exempt or confidential. So we began this training by explaining that this really is a maze of processes and different avenues for requesting things, etc. It's important to note that I totally lost what I was thinking, and I apologize for that. So I'm going to smile and advance the slide. Here we go. All right, so the fees for inspecting a record. We've explained today that you can go and look at a record during working hours, but what about inspecting them? What about copying them? Can you bring the old James Bond microfiche camera and take slide pictures? Here's a little bit about how that works. So Public information must be open for inspection without charge unless otherwise provided by law, which is important to note. I mean, a lot of public records requests and responses really get into dollars and cents. My organization, Disability Rights Florida, we're very fortunate that we have the financial capacity to seek and receive records, through these processes, but not everyone does. So it's important to know that the inspection of public records doesn't necessarily trigger a cost. The Act, however, and here's the first time we're encountering special service charges. And we'll talk a lot more about special service charges as we're moving forward. So the Act authorizes the imposition of a special service charge for the inspection of public records when, quote, the nature or the volume of the public records to be inspected is such as to require extensive use of information technology resources or extensive clerical or supervisory assistance or both. And however, any charge assessed must be reasonable and based on the labor or computer costs actually incurred by the agency. So if you're seeking records that the Department of Juvenile Justice lets you know are going to be available in room 312, with the supervision of the records custodian, next Tuesday, if that's when you would like to come in and see those records, that's absolutely okay. It's important to know that the individual that's supervising the affair, it's very likely the agency will seek a charge for the supervisory capacity. It's also very likely or reasonable if the agency has to do extensive IT splunking or searching to get those records. All of that can get funneled into what constitutes a special service charge. Same token, though, and you will find this. There's a lot of agencies out there, and this really is, I think, how the public records law is supposed to be conceived of. You will find agencies out there that, if there's a batch of records that you're interested in reviewing, absolutely come and they'll be in this folder and awaiting you, and on a date and time, etc. And the agency won't get too heavy into the special service charge or the supervisory charges that could attach as well. Um, so we'll move forward. And here's another note on inspecting records real quick. So the Act provides a right of access to public records for the purpose of making photographs of the record while such record is in the possession, custody, and control of the custodian of the public record. So any such photographing is to be done in the room where the public record is kept. However, if in the custodian's judgment this is impossible or impracticable, the copying shall be done in another room or place as close as possible to the room where the records are kept. This really isn't only talking about the James Bond little like spy cameras. They do, I think, I'm not too good at technology, but I think they do make scanning documents that are somewhat portable that folks might be able to bring to a room that they've been allowed access to inspect records at. So just understanding this is a little bit of how that all breaks out. Um, and where the provision of another room or place is necessary. And, if you think back to what constitutes a public record, that absolutely could be the case. The expense of providing the same shall be paid by the person who wants to copy the record. So if what we're talking about is records that are in 75 boxes, and the only way to get those 75 boxes staged is in a room down at, a separate like off-campus building or something, or where the records are held, like the cost of making that room available or having an extra room will be borne by the requester. And the records custodian may charge the person making the copies for supervision services, like we mentioned. So keep all of that in mind when you're trying to just inspect the records. But most folks aren't really looking to just inspect or don't bring the James Bond spy gear into the room. Most folks are trying to get copies of records. So, what are the fees for copying records? Well, if no fee is prescribed elsewhere in the statute, the Public Records Act authorizes the custodian to charge a fee of up to 15 cents per one-sided copy for copies that are 14 inches by 8.5 inches or less, which I think that's legal paper. And agencies may charge no more than an additional 5 cents for each two-sided duplicate copy. Those totals add up real quickly. Let me tell you. If you're doing agency work, I mean, if you're doing like advocacy work as a part of an agency or an organization, like a lot of records you're after sometimes come in batches of 4 or 5 thousand records. So the cost of receiving all of that can certainly add up quickly. However, for other copies, the charge is limited to, quote, actual cost of duplication of the record, which is defined to mean the cost of the material and supplies used to duplicate the public record. And that concept doesn't include the labor costs or overhead associated with duplication. Really, what we're talking about here is if you wanted a copy of a map, that is held by an agency. It's absolutely a public record, absolutely inbounds to request as such. But if the agency is to make you a copy of that map, short of just giving you their own copy of that map, you would have to pay for the duplication costs of that map, in addition to other special service charge considerations. And here we go. More on the special service charge. So, 3 slides coming up. So when warranted, and when you're looking to copy records, a special service charge for extensive use of clerical or supervisory labor or extensive information technology resources applies to requests for both inspection and copies of public records. So while an agency may not refuse to allow inspection or copying of public records based on the number of records requested or the span of time which is covered in the public records request, if extensive use of IT resources or clerical supervisory personnel is needed to produce the requested records, the agency may impose a reasonable special service charge that reflects the actual costs incurred. And just a note that I have written in my paper here that I wanted to mention. So that charge must be calculated using the hourly rate of the lowest paid employee capable of performing the task. So again, an agency isn't allowed to frustrate the public records law by only allowing some senior, psychologist making $400 an hour to be the one to go pull the records. And hey, sorry, DePalma, if you want those records, the senior psychologist is going to charge $30,000, for their time to go and get all of that information. So just know that when you're computing the special service charge, it is, quote, calculated using the hourly rate of the lowest paid employee capable of performing the task requested. Advancing to slide 2 here. There's no definition or legislative intent in the act for what may constitute extensive use of resources or personnel, which is to say there isn't really a threshold or a watershed or anything like it. The Florida Attorney General's office suggests that agencies implement the service charge authorization, quote, in a manner that reflects the purpose and intent of the Public Records Act, and that does not constitute an unreasonable infringement upon the public statutory and constitutional right of access to public records. I wish that was the case. I wish that I feel like for some agencies, no matter what you're requesting, depending on who you are and maybe even why you're requesting it, that special service charge does tend to get tacked on to those pesky prying eyes types of requests, even though it doesn't necessarily have to be in every instance. But the AG's office also strongly encourages agencies to adopt the public records procedure that addresses imposition of special service charges. That's to kind of alleviate concerns that games will be played with particular requesters or particularly requested information. Like if the state agency or a responsive entity has a well-established public records procedure that they can turn to, the likelihood of games like that or of attempts to frustrate requests like that are minimized, I think. So, excuse me 1 second. Ow, I don't know how to hit pause. I have to cough. Sorry about that, y'all. So, any special service charge must be reasonable, as, quote, excessive charges could well serve to inhibit the pursuit of rights conferred by the Act. So, agencies really shouldn't be using public records requests as an opportunity to run up the bill, to charge, a bill of goods, a huge invoice, or anything like that. Everything should be reasonable. This is really the heart of what you'll find yourself arguing with the state and perhaps even courts about, is kind of how these charges are calculated, how they're imposed, whether they're imposed equitably for everyone, whether they're only imposed for you, the particular pesky requester who won't stop asking about this information, etc. So that's a little bit of how that stacks out. The final slide about special service charges. So the definition for information technology resources is defined. So that is the data processing hardware and software and services, communications, supplies, personnel, facility resources, maintenance, and training. So incidentally, this term does not include a videotape or a machine used to view a video. That's pulled right out of the Sunshine Manual. I probably should have said that much earlier in the presentation, y'all. Everything in this presentation is cribbed from the Sunshine Manual. I fessed up early and said that I am no expert on all of this, but I am well acquainted with the Sunshine Manual and have been very diligent in my attempts to make sure that everything included in this training is, sort of flows from the Sunshine Manual specifically. So similarly, under IT services, the fact that a request involves the use of IT resources is not alone sufficient to incur the imposition of the special service charge, and rather it's the extensive use of such resources that's required. So just the fact that you're asking for something that is on an IT server or service or might require IT to help do a email hit, like I would like all email correspondence that have this phrase in them. Again, I think most ITs, maybe honestly, most all of us are able to go to our Outlook and kind of use Boolean search terms and figure out what might be produced if we were to hit our inboxes with that term. IT is certainly able to do that simply and probably off the cuff. So I don't know that that would, on its face, be extensive use of IT resources, but final point here, an agency is not ordinarily authorized to charge for the cost to review records for statutorily exempt material. Which is to say, if you make a request looking for one particular thing in a sea of other things that you know are going to be redacted back to you, the agency isn't able to charge for the cost to review the statutorily exempt material meticulously. Uh, Again, aren't able to come back and be like, hey, we found the one piece of paper in the 30,000 pages of exempt material, but it took us 3 years to read those 30,000 pages, word by word. So that's kind of out of bounds. However, the special service charge may be imposed for this work if the volume of records and the number of potential exemptions make review and redaction of the records a time-consuming task, which kind of just negates what I said, but I was sort of just illustrating. You can imagine that if the request involves extensive redaction, extensive review, a special service charge is likely in bounds. But again, just make sure that what's being extensively reviewed isn't the line by line of things that are obviously redacted. I think that's the point here. So moving forward, I now see the clock on my screen, so I'm doing my best to make sure we're staying close on time. All right. How do you get these records? Like when do you, I mean, you've made the request, you've gone through the back and forth with the agency. When do you get the records? So the Act provides that the custodian of public records shall furnish a copy or a certified copy of the record, quote, upon payment of the fees prescribed by law. So notably, an agency's policy of requiring the payment of a deposit prior to redaction and delivery of hundreds of telephone recordings related to a criminal trial was determined to be facially reasonable. An agency may refuse to produce additional records if the fees assessed for a previous request have not been paid. So, kind of tying back to that whole notion of a standing request, if it's your beeswax that you want to make a public records request to the Department of Juvenile Justice, uh, every Tuesday for the entire calendar year, that can be your beeswax. But each request you have to make, or each request you are making, like once you've engaged the agency and they respond with the fee that it'll cost to get those records, you can't just keep adding on new requests. You can't keep an agency sort of chasing its tails through Chapter 119. Also, an agency is not precluded from choosing to provide informational copies of public records without charge. So you'll remember when we began this presentation, I was like, oftentimes the easiest way to get a record is just to ask for it. Sometimes it's because who you know, or you have a friendly relationship, some rapport. But all that is to say, an agency is not required to put you through the rigmarole. to get a record. An agency, especially in 2026, when uh, records live electronically in many different varieties, many different capacities, there are often a lot of ways for an agency to get you the information you want quickly and without expense. And so just holding on that note for a second. And importantly, the act does not, unfortunately, prohibit charging inmates of indigent requesters upon request. What am I saying? The act does not prohibit charging inmates or indigent requesters upon request. So even if a request comes from someone without a ton of means or from someone who's incarcerated or detained, this all still applies the way it does. So just keep that in mind if that's a part of your work. All right, we're nearing the end here. I am on slide 28 of 37. We are at 1 o'clock. I think we're doing okay. Um, oh, the responses you will receive. And boy, that is true. You know, there are many agencies, there are many advisory boards, there's many commissions, there's many private entities working as agencies in effect. There's subcontractors. And sometimes when you ask folks for the records you want, you'll get some really ridiculous responses and those shouldn't throw you. I think it's important to note that the right way to proceed is to always go back to that board game that we've turned over and put all the pieces out and to look for what your remedies, what your rights are, how to compel production, etc., how to push past what very likely will be incorrect or obtuse or convoluted responses that you'll get from a responsive entity. So we've made it to slide 29 and we haven't really dug into what is an exemption or when is a record confidential? So courts cannot judicially create any exceptions or exclusions or exemptions to the act. That's wild. Instead, the legislature is specifically authorized to enact general laws creating public records exemptions, provided that such laws, quote, shall state with specificity the public necessity justifying the exemption, and shall be no broader than necessary to accomplish the stated purpose of the law. So, public records exemptions and the framework for records that are made exempt in law is very serious business. I have an opportunity to work at the Capitol in legislative work all the time. Folks who also have an opportunity will know that public records uh, legislation is passed separately, uh, has its own bill, standalone bill that includes that public necessity statement. They are very frequently tied to another bill, the actual subject matter of a bill that the public records exemption is being requested for, uh, and many open government sunset review. There's a process called open government sunset reviews. A lot of these public record exemptions are reviewed at a certain set time, like every 4 years, every 5 years. And if the legislature doesn't renew them, then the exemption goes away. So if you really kind of pull back the aperture of it and think about it, all of that means that this is all incredibly serious stuff that one legislature should not be able to bind all future legislatures for how it works. One electorate uh, of Floridians should not be able to bind how all of this works for all future generations. Like this really is supposed to be a living, breathing, constantly under review and consideration type of law here. So, and again, because the state's public policy favors disclosure, quote, the Public Records Act is construed liberally, maybe literally, let's say liberally in favor of openness, and exemptions from disclosure are construed narrowly and limited to their designated purpose. So that should kind of affirm and reaffirm how this is supposed to work for y'all. So there is a difference between records the legislature has determined to be exempt through the process we just described, uh, and those which the legislature has determined to be exempt from the act and confidential. So if information is made confidential in statute, and there's many examples of information in the statutes that's made confidential, that information is not subject to inspection by the public and can be released only to those persons and entities designated accordingly within the statute. If records are not made confidential, but are simply exempt from mandatory disclosure, the agency or records custodian is not prohibited from disclosing the record in all circumstances. And that's a little in opposite if you're thinking through it. The takeaway here is once an agency has, quote, gone public with information which could have previously been protected from disclosure under the Act, no further purpose is served by preventing full access to the desired information. So once a record sees the light of day from an agency, it's in the public eye from that point forward, which is to say that if you seek that record again, an agency can't thereupon be like, well, at one time felt that that was okay to, respond under 119, but now we've changed how we feel, so we're not responding with that any longer. That record is no longer exempt. It's lost its protection, unless, as we mentioned here, it's been deemed confidential statutorily elsewhere. So here's a little bit about maintenance and storage of records. Again, as we continue forward towards the year 5000, this will probably become a lot less important, at least in terms of physical possession and physical storage and physical maintenance. But, out of respect for the fact that these laws came to us from the last century, all public records should be kept in the buildings in which they are ordinarily used. Thus, public records may not routinely be removed from the building or office in which such records are ordinarily kept, except for official purposes. Therefore, the retention of such records in the home of a public official would appear to circumvent the public access requirements of the Public Records Act and compromise the rights of the public to inspect and copy such records. Uh, that's a lot to unpack. I think it's important to note that a request can't be frustrated by saying like, hey, yeah, Jim has that record, but Jim took it home and his house is a mess. We're really not sure where he keeps everything, under the George Foreman grill or whatever. So we're probably not gonna be able to get you that record. Like that would be Jim's fault for having public records stored and maintained that way. Some of this has probably changed or morphed or transmogrified throughout COVID in different regards. So, be aware of that as you're looking at these things, but just know that the public records laws can't be frustrated by essentially hiding records or taking them different places. And whoever has custody of public records shall deliver such records to his or her successor at the expiration of their term of office, or if no successor, to the Records and Information Management Program at the Division of Library and Information Services of the Department of State, which is a wild thing. Let me tell you, that's really not how this tends to work in state government. My first day in my executive state agency, I had all of the work from the person who had just left the week before right there. Uh, and I don't know that that chain of custody was really front and center in anyone's mind nearly as much as like, hey, so and so is gone now. You have to do their work. But that's how it's supposed to work. All of the records are supposed to be delivered to the successor custodian. And maybe 30, 40 years ago, that was a very like ministerial process, something like we had trumpets and bugles and here's all my boxes of everything. But, just know that uh, another way that the act should not be frustrated is by saying that, hey, that record you're after, we've had a lot of turnover since then, and two or three other people have taken that record now. We're not sure who has it at this point. Like that is a violation of the act. So moving forward, slide 32 of 37. So the retention scheduling is uh, it's kind of really dense. So I'm not going to put the actual scheduling up here, but the act requires the Division of Library and Information Services, DLIS, at the Department of State to adopt rules establishing retention schedules. And they're out there, trust me, and a disposal process for public records. So public records may be destroyed or otherwise disposed of only in accordance with retention schedules established by a division, and officials must, quote, systematically dispose of records no longer needed, subject to the consent of the division. Statutory restrictions on the destruction of public records apply even if the record is exempt from disclosure. So just because there's an assertion that it's an exempt record doesn't mean you can shred it Arthur Anderson style or anything like that. If an assertion is made by a custodian that a requested record is not a public record subject to public inspection or copying, the required record may not be disposed of for a period of 30 days after the date of the request. That's sort of a standalone consideration for the timing of requests and retention. And just again, one through line for all of this training is that I am no subject matter expert on this nearly as much as I'm an advocate like you trying to understand how these rules work and how to commit to strong advocacy through that. I included the contact information for the D-List State Record Center and their email address. If you have specific questions about finding a record that may have been destroyed or to find what retention schedule should have applied to it, those are the folks that you'll want to turn to. All right, nearing the end here. This is the final section, y'all. This is remedies and penalties for non-compliance. Again, this is some of the stuff that I especially would commend folks to consult with legal counsel about if they're interested in what to do if an agency frustrates an effort to receive a responsive record. So, important to note up front that Florida has established an informal mediation program within the AG's office as an alternative for resolution of disputes. So if there's a need to avail yourself of that process, please be aware that it exists. And then the important thing, civil action. So a person who is denied the right to inspect and or copy public records under the Act may bring a civil action against the agency to enforce the terms of the Act. No surprise there. Service of process aligns with Chapter 48. A writ of mandamus is an appropriate remedy to enforce compliance with the Act, and a petition for writ of mandamus is an appropriate vehicle to challenge a denial of a public records request, even where an exemption has been asserted. So if there's a need to compel an agency to comply with the Act, that is the process to do so. And injunctive relief may be available upon an appropriate factual showing, i.e., demonstrated patterns of noncompliance together with the likelihood of future violations. But injunctive relief is inappropriate if acts complained of have already been committed and no well-grounded probability of similar future conduct. So even though an injunctive relief is in bounds, if you can point to a pattern and a practice of frustrating the act or non-compliance, it really isn't the appropriate relief in a civil action. More on remedies and penalties. So after receiving a request to inspect or copy a record, an agency may not respond to that request by filing an action for declaratory relief against the requester to determine whether the record is a public record or the status of the record is confidential or exempt under law. That actually sort of became the playbook for a second from agencies as they were receiving public records requests. Again, maybe out of a genuine curiosity about what type of declaratory relief the court could offer in some of these instances, but very likely also because it was a good way to kind of hold these requests at bay for a time. The Act does not create a private right of action authorizing the award of monetary damages for a person who brings an action to enforce the Act. So there is no monetary damages. So payments by the responsible party may include only the reasonable cost of enforcement, but that includes reasonable attorney's fees, which are directly attributable to the civil action brought to enforce the Act. That all makes sense if you think about it. All right, last slide regarding penalties and remedies. So the Act mandates that actions brought under Chapter 119 are entitled to an immediate hearing and take priority over other pending issues. That should underscore just how important the court takes these issues and should receive these issues. In cases in which an exemption is alleged to exist, the public record or the part of the record in question shall be submitted to the trial court for an in-camera inspection and examination. And if the person seeking public records prevails in trial court, the public agency must comply with the court's judgment within 48 hours unless otherwise concludes the record, if you are a prevailing party, should be yours. Information. Like I said, I do not work for Public Rights or Public Records Rights Florida. I'm a disability rights advocate, but I would be more than happy to look at any issues that folks have and try to arrive at a right path of resolution. So thank you so much for your time. And Jorge, turning it back over to you.
All right. Thank you, Tony. Amazing presentation. I wish I had this presentation like 5 or 6 years ago during COVID because I was trying to request public records for emergency rental assistance data. So I was able to get some of the data successfully, but I did hit some roadblocks and I really didn't have any idea how this all works. So I wish I had this back then. So I'm really glad you presented on all of this. I did see a few questions come in the chat. I'm going to read them out loud. But before I do so, I'm going to drop the link to the materials again. I also found the Sunshine Manual that you referenced, Tony, and in that link, you can find both the PDF manuals, including the law enforcement one that was referenced by Tony. I included them in the materials as well, but Tony mentioned they were last updated 2025. So in case they are updated again in the future, that link should take you to the most up-to-date version. So I will also drop the CLE code. I'm going to read it out loud for the benefit of those that cannot access the chat. The CLE code is 2606640N as in Nancy. That code will also be going out via email, and it will also be included in the YouTube description. I'm gonna scroll back up to see if I can find some of one of the first questions that came in. I do see people that have their hand up. I can allow you to talk and bring you off mute, so I'm not sure if you did that inadvertently, but I see Rachel and Glorianne. If you do have a question, I'll try to bring you off mute. Okay, I see one of them was out. So I will find the question here. So I think I may have the answer to the question, Tony, but I'm going to let you answer it. But I will plug a webinar that we recently handled. The question was basically if all of this applies to HOAs. And the reason I wanted to plug a webinar is last week we hosted a webinar on HOAs, and it was mentioned how HOAs feel like a little government, right? So I think I know the answer, but I'm going to let you answer this.
Yeah, and I would say again, always consult with legal counsel if you're able. But I believe that the Sunshine Manual, if you start reading into that, will explain all the ways that HOAs can be considered responsive entities under the totality of factors test or different regards. So basically, if a homeowners association is doing anything with government and doing processes or activities with a government, which many homeowner associations do, although I don't know HOAs close enough to know that they all do. But I certainly believe that a review of the Sunshine Manual can help get your information about when and how HOAs might be responsive under the Public Records Act.
And I add I will include the link to this to the HOA webinar that we had because it was covered under a different statute under 720. How do you specifically request records from HOA? So maybe the Public Records Act, it's not necessarily the best way to do it. There it may be other relief under another statute as well. So
Thank you, Jorge. I
I
should have phoned a friend there.
I see another question here. I'm going to read it aloud for the benefit of the audience. How long do you think is reasonable and a reasonable amount of time for an agency to respond to an uncomplicated request? In other words, how long should one wait before taking legal action if there's no response?
Yeah, I think that'll be different in every instance, depending on, I mean, you mentioned the person asking the question mentioned an uncomplicated request. You know, that could be received differently by an agency. I mean, what might be uncomplicated to you or the requester might be complicated to the agency for different regards, either in the hunt to locate the document. And again, slides that we presented here today mentioned that, you know, the reasonability analysis or the analysis of what's reasonable really does tie to, how the agency does its splunking, does the reasonable time to respond for production must tie to the time it takes to locate the record, review it, and redact it. That's really it. I mean, it might be that you're requesting something that's politically combustible or that an agency doesn't want you to receive. None of that should factor into how long it takes you to get it. So if what you're after is something that should be readily available, doesn't require extreme review or redaction, and you're being kept at bay for a long period of time, again, I would consult with counsel to make sure that they agree with, your sort of assessment of things. But I would say that that trends towards unreasonable delay.
Thank you. I'm gonna check the Q&A just in case any other questions came up. I don't see any in the Q&A, but we still have a few more minutes left. Let's see if anybody else has any questions. I do see a lot of thank yous and great presentation, and I fully agree, Tony. This was a great presentation. A lot of content, and I found those manuals like 400 pages worth of content in there, so it's not an easy task to condense all of this into a presentation. You did a great job.
Thank you. Thank you.
Right?
And even if
I
folks
see.
don't have questions here on the spot, like please, like I was joking throughout that I'm not really an expert on this, but I am really interested in how this all works. I especially am interested because I've seen it and trained on it from inside a state agency and at an advocacy organization. So, I imagine that receiving this information, depending on who you are and who's giving it to you, can be worlds different. But if anyone has questions or thoughts that spring to mind after the fact, please get in touch with me. I might not have the answer immediately, but I promise you I will go hand in hand with you to go try to find the information for sure.
All right, we do have one more question that just came in, and the question is, do contracted private entities like CBCs fall under the statute?
Yes. So contracted entities, subcontractors, again, it really depends on what they're doing. So community-based care agency, if they are working with a managing entity, if they're working within state government service delivery somehow, then yes, they would be a responsive entity. I don't want to paint with a broad brush and say that that's true in every instance in all regards, which is why again, I think the Sunshine Manual is fascinating because it really is the law of the land. It's up. All the annotations are updated by the AG's office. The publication and the distribution goes to First Amendment Foundation. Everyone trains on it, but that you'd be surprised how much you can learn by going to the manual and using the search bar and just kind of typing different terms, trying to use the table of contents to get into the section of law. Some of it is really dense, really, legally dense as well, which cuts against how I think that Chapter 119 is supposed to be a very pro se chapter. It's supposed to be actionable by folks without legal education or training. But I do think that even for those folks, the Sunshine Manual is a great thing to have at the ready, a great thing to get comfortable doing word searches in. And if you do those word searches and can't find the answer you want, again, consult with your legal counsel, but always know that I'm out there in the wilderness and other folks are too, and we're always happy to look at things together.
Okay, I see two more questions in the Q&A, and here's one
Do
of
I,
them.
do I
The
get paid
first
by
one
the
is,
question? Do I get paid by the question?
well, it depends. We'll have to check the statutory authority and see if it's a special service fee. Okay, so the first question is, have you dealt with lawsuits for failure to timely produce records?
Yeah, we have. And without going into what those lawsuits were about, they were there were moments where our agency and our organization got with partners and kind of looked at how what the statutes were saying should be available, like what records should be kept and should be created. And we were asking for those records from an agency. And the responses we were getting back was just that those records don't exist. No one keeps those records. The entities we're trying to ask for those records from don't have them. And, the whole time we're looking at a statutory text that says, like, all of these entities will receive the following records and reporting as such. And so we knew that there was a statutory obligation, but the responses we were getting were just so convoluted and so frustrating that we filed litigation. And again, I don't know if this is always the case, and I don't want to misspeak or speak out of turn here, but sometimes getting in a posture like that with an agency around a 119 issue can sort of result in settlements and discussion differently than other types of litigation. I mean, I mentioned that the Attorney General's office has a voluntary mediation capacity. Something like that tends to kind of commence, I think, around a lot of 119 litigation, when it's filed. And I don't think that litigation or the threat of litigation or the hammer of litigation should really be the moment that an agency takes a request seriously and does respond. But all that said, though, the legal requirements here are court enforceable, and they create a right of action for requesters that have been frustrated. And that's by design. It's been that way for longer than I've been alive, and probably a lot longer than I will be alive. And it's for a purpose. It's for a purpose because Florida long ago decided that the business that being transacted within this state by its state officials is the business of the people. And the people have the right to those records to understand that business. Exemptions and confidentiality exists, but this is information that Floridians and non-Floridians, right? Because no one can require you to turn over your driver's license to make a request. You know, people from Boston can ask for this information if they'd like. But it's all by design. And again, it's one of the reasons why I think Chapter 119 is a fantastic chapter of law that I turn to regularly. It's buttressed right up against Chapter 120, which is another fantastic chapter of law that I turn to a lot. And I think both of those two chapters are supposed to be for the purpose of giving constituents and Floridians power to request and receive the information and the answers and the due process that they deserve as Floridians. So.
All right. One last question. Do you have any templates or information that must be included in a letter to make a public records request?
At DRF, at Disability Rights Florida, we have templates. You know, I would answer this question by going back to a slide that said there is no format that's required. There's no buzzwords, there's no magic words. You don't have to have a letterhead, you don't have to have a JD or an ESQ after your name. You can make it in an email. You could technically, although it's inadvisable, make it over the phone. So there really isn't like magic words or requests. All that said, though, if what the question's asking is, do we find that templated information tends to increase the responses and the responsivity of agencies? Yeah, I think it can help. I think templates are out there and available, between partner organizations. On our template, I include a list of words at the end of the document, something that you might see in a like a court document or a discovery request, just kind of fencing in folks because no surprise to anyone, for folks on the inside of state government that are training around this material, sometimes the game is to not have to turn something over because the request was made an incorrect way or was referring to it this way when they needed to refer it to that way, et cetera. But all that said, I don't think that templates are required. I think that developing a framework for making these requests that agencies take seriously and understand with precision, hopefully what you're asking for are always helpful. Um, Maybe the best way to answer this question, Jorge, is if you make a request that isn't templated language and you get a call back from the person you're requesting, like, hey, Jane, got your request, wasn't really sure what you were asking for, didn't know, like those can actually be very helpful piggyback conversations. Because that's that plain language opportunity, right? Someone might be like, hey, Jane, I don't really know what you're asking for, although I'm perfectly happy to go and try to find it. And that might be Jane's opportunity to be like, well, Tom, what I'm looking for is this, this, and this. And that can even help kind of land on making Chapter 119 a little bit more, constituent friendly, a little bit more, pro se friendly. Um, the long-winded answer to your question is no templates needed, although I do have some and I'd be happy to share anything that we do have with anyone that's interested.
It's and Tony, I love that answer because my first public record request was related to DCF and I had no idea what I was doing. So I actually dropped a link in the chat because I started Googling like DCF public records request. All I wanted was data and rental assistance and how it was being spent through specific counties. So, and that I found that number in that page. I called, and even though I did submit the request formally, it was more of a matter of asking. They were actually happy to provide the information. So, when I got on the phone and I clarified, like, hey, here's what I'm really looking for, they were just, here you go. And at some point, they started sending me like the information on a weekly basis without me having to request it. So
And
it
that
worked
is
out.
a grand illustration of what I was saying. Something we mentioned first. Sometimes the easiest way to get a record is just to ask. And it's not just because like, hey, have you considered asking for something? It's more like that conversation can just lower tensions, lower frustrations, lower the adversarialism, and just kind of get to the heart of the matter, like what is being requested. The question of why are you requesting that, Jorge, is really out of bounds. But if the question like, hey, Jorge, got this request from you, not sure exactly what you're after. Is this what you're after? Or would it help you to look at this? Like those are tend to be how those piggyback conversations go more often than not, I think.
Well, we don't have any pending questions. We're at time. I want to thank everybody that joined us today for another great webinar. And thank you, Tony, for an amazing presentation. We look forward to collaborating with you and disability rights further in the future. So thank you, everybody. Have a great rest of your day.
Cool. Thanks, Jorge. Thanks, y'all.